Dear aspirants, hello and welcome to this video lecture on behalf of CLAT SATHEE. This is Dr. Animesh, your criminal law friend, the criminal law instructor, and today we are going to discuss some of the other offences against property. This is the third lecture for offences against property. In the last two classes, we have discussed theft and misappropriation, then we discussed robbery, extortion, and then we discussed Dacoity, and all those things will continue today. We'll discuss some other offences of criminal breach and trust, cheating, forgery, and everything. So I hope you are ready. Let's get on to it. Yes. First thing, CBT, criminal breach of trust. Now this looks very intimidating. Actually, the section is also fairly technical, but we'll try to take a simple understanding of it. That section is actually critical and difficult to understand in jurisprudential sense. But I'll give you a basic fair idea about. Now, criminal breach of trust starts with a person entrusting a property to someone or entrusting a dominion over it. See, either you give someone property or you give any right over that property to someone. To take few examples, suppose I have some money and I have given that money to you. Now, obviously, purpose is very material. Entrustment means I retain the ownership or control over that property while giving that property to you. Giving dominion means that even if the property is with me and still in my control, I have given you some right over it. I'll obviously explain it again. See, entrustment simply means that you have given someone some property for some purpose. Whenever we say a trust is created, it means that somebody has given someone property and other person becomes trustee or custodian of that property, and that person will have to dispose or deal with that property in the manner owner has stipulated. Looks very technical, but I'll give you a basic idea. See, suppose I give you 10,000 rupees and say, कि भाई, my brother is coming tomorrow by train. Once he'll reach Delhi, you should give him this 10,000 rupees. He's in need of money. He's coming by train tomorrow. So please give him this money. Now, what is this? This is entrustment of property. I have a friend, let's say Mr. A. I have given 10,000 rupees to Mr. A and have instructed him that once my brother will come tomorrow, you hand over this money to him. Now here, I have given this money to Mr. B, the person B, and I have given the money to Mr. A to give it to my brother B. Now here I have created a trust in favor of Mr. A. And my that particular person, Mr. A, is obligated to use that property, dispose of or use that property in the same way that I have stated. That is what we call entrustment. We entrust our money all the time to other people. Like I suppose I have, how many of you have heard the ad mutual fund sahi hai? Mutual funds. What happens in mutual funds? In mutual funds, there is a particular person who is supposedly an expert in share market and everything. Instead of directly investing in various company, I give my money to a fund manager, a person who has vast knowledge in share market, and now he will invest my money in different companies, and obviously whatever the profit is there, he will give it to me. So when I have given my money to mutual fund, I have entrusted. I have not given charity. I have not donated that money to mutual fund. I have entrusted my money to that particular company or mutual fund. Now, if I have taken a mutual fund, in that case, that fund manager is entrusted with my money. Means Suppose he takes that money and runs away. Now what he has done? He has done breach of trust. So entrustment is very important. When you have given someone money or property for any purpose, you have not given that property to him completely. If I use it as you may please. But for any purpose you have given. In that case, there is what we call entrustment of the property. When you have entrusted someone with the property, it means that you have given some limited right of over that property to that person. You have given that property to that person and said कि भाई इस property का ऐसा इस्तेमाल करना. That constitutes trust. And obviously that person has to agree. That person agreed कि yes, whatever you have said, I'll do. Correct? मैंने किसी को पैसे दिए, suppose I entrust my monies to Zomato so that the Zomato will pay the hotel and I'll get my food. I don't pay the hotel directly, restaurant directly, whosoever is selling the food. You not pay to them. You give the money to Zomato in advance. And you have instructed, there is an implied or the very express agreement between you and Zomato that that money should go to the restaurant in lieu of the food that I am given. Suppose you paid money to Zomato, Zomato runs away with that money. They do not pay it to the hotel or they do not forward it to the restaurant so that you can get your food. That will call breach of trust. But when you have given some money to someone for some purpose, that is entrustment. And if there is some kind of entrustment, that in that case, if that trust is broken, that is breach of trust, will come to that. Other part is dominion over it. Sometimes you don't give the property away to someone, but you give a dominion or right of over it to someone. Like simplest arrangement. Suppose I have a bike. I give a key of that bike to my friend or a neighbor and say, bhai, whenever you want to use it, you can also use it. Now that is giving dominion. I'm not entrusted with the property to him, but I have given a right over that property to that person. Okay. Like a friend comes to you, suppose you have silver spoon or golden spoons in your house and guests come and you serve them food. So the cutlery, obviously they are using cutlery and that cutlery suppose is made of silver. Now you have not given the cutlery to them, but you have given them the right to use that property. So that is what means dominion over that. Suppose they take that cutlery and they just put it in their pocket. Try to run away. तो चांदी का चम्मच अगर वो चुराने का प्रयास करते हैं, ले जाने का प्रयास करते हैं, तो what they have done is criminal breach of trust because you gave them dominion over your property. When you give someone permission to use that property or allow dominion over that property, but suppose you gave criminal breach of trust. Another example, a very interesting example. Suppose you gave a key of your house. Suppose you are going someplace. Suppose you live in a particular place. Suppose you live in Lucknow, and you have to go to Delhi for a month or two for any purpose. Now you have a house and suppose you have plans. So you give a key over your house to your friend and say कि भाई ऐसा है कि in my absence water my plants and if any emergency I'm giving you a key. Now that person starts using that property as Airbnb or Oyo hotels or something. He starts giving it to the other people on rent. Now what he has done? You gave him dominion over a property and now that dominion was supposed to, that trust, you entrusted him with a right over a property and he used that property in violation of your trust. That is what we call criminal breach of trust. For criminal breach of trust, there has to be entrustment. आप किसी पर भरोसा करें. You give them property itself or you give them right over it. या तो आपने प्रॉपर्टी दी हो या उसके ऊपर कोई राइट दिया हो. जैसे घर की आपने चाबी दी So you gave them right to enter that property for a particular purpose, to water your plant or to feed your cat. But they broke that trust and started using the property in which it was not supposed to be used. In that case, it will be considered as breach of trust. Now, suppose you gave your horse to someone. Okay. कि भाई ये horse मैं आपको दे रहा हूं, this is my horse, I am going someplace else. Now your only job is to feed this horse, to maintain this horse simply. I am giving you this horse, you just maintain it. Now let's say they take that horse to a horse racing and they start using that horse for horse racing purpose, for betting purpose. Now that is what we call a breach of trust. So obviously the first element is entrustment with the property. You have given a property to someone with certain purpose, means you are still controlling how that property is to be used. There is a proper use of that may be express or implied. When I am serving food in a silver cutlery, it is an implied agreement or implied understanding that once they eat, they will leave the cutlery. It is common sense that nobody takes away the cutlery home. So that is what we call entrustment. I give that property, or in an express way or in an implied way, I have also given instruction about how that property is to be used. That is what we call entrustment. Now the other person dishonestly misappropriate. Now, dishonest is very important. There should be an intention of wrongful gain or wrongful loss. So he misappropriates or converts the property into his own use. Now, that constitutes criminal breach of trust. Now, obviously, if that act is not dishonest, let's say the person whom I gave money to be handed over to my brother, now that person is a little bit dim-witted. Bhola vyakti hai, mund buddhi vyakti hai. Now he goes to a station and the first person he sees, and he goes and he asks, "Are you brother of Professor Animesh? He has given me money for you." Now what do you expect of the other person to say? Yes, I am the brother, give me the money. So he takes the money and goes away. Now, here in this person caused me very grave loss, 10,000 rupees loss. He didn't find my brother actually. He gave that money to some random person. Now that is wrong, is that I have suffered wrongful loss. But whether it was his intent to actually whether his intent was dishonest, whether his act was intended to cause wrongful loss, answer is no. Suppose I have a servant and I gave that servant some money and asked him to go and buy the shares. I have an agent and I have asked him that you go and buy shares of company A in my name. Go and buy shares of company A in my name. Now he goes and he thinks he is very smart, very hushiyar, very intelligent. He thinks company A is going in loss. Malik knows nothing and he will lose all his money. So what I should do? I should buy some bitcoins. And now the money will be doubled. I'll get promoted. Malik will be very happy. So he instead of obeying my order, bought some bitcoins from that money and lost all the money. और उसने Dream 11 पे team बना दी और IPL is going on, so betting season is on. And when making this video, IPL is going on. So with IPL betting season comes, so he bets my money in IPL. Now obviously his intent was that he will disproportionately gain money from that and he will give me back my money. Now what he has done is wrong. I'm not saying that's not problematic, but it's not criminal. Why so? Because the intent is not dishonest. His intent was कि मैं पैसा जीत कर मालिक को दे दूंगा. He never intended to misappropriate or convert the property to his own use. He was not If his intent was ki I will gain much money from this, and I will also keep some money and I will give the master to his money, then it will become dishonest, because his intent was to wrongfully gain from that property. But suppose he completely placed the bet in my name, thinking that I will, whatever the win will, whatever the victory or whatever gains will happen, will go to me. In that case, his intent can't be said to be dishonest. It's foolish. Only an imbecile bets money on a sporting event. You do not wager money. हाँ. And I'm just moral ज्ञान, छोटी छोटी मगर मोटी बातें, but moral ज्ञान is that do not bet money on sporting event. Money is hard-earned money. Those who have to work hard, they never bet the money. You work hard for money, then you will understand the value of it. Obviously, your parents must be saying this to you all the time, but obviously, if you want to bet the money, earn yourself, and then bet the money. Then if you lose the money, let's see how you feel about it. Okay. And that misappropriation or conversion must be in violation of that entrustment. That is what we discussed. Whatever trust was made, in the sense that whatever property was given on a trust, if that trust is breached, I gave you money for a particular purpose and you used it for your own benefit, you have committed criminal breach of trust. I gave you money to put in the bank, in my account, you use that money to buy a watch for yourself, you have committed criminal breach of trust. Criminal breach of trust in simplest sense means that somebody gave you some property for a particular purpose. Even if they ask you to destroy that property, instead of destroying that property, you use that property, that is also criminal breach of trust. Whatever, if a person entrusted you with the property, or he gave any right over a property to you, and you simply used that property against that particular directive. That person gave you the property for a purpose, for some instruction was there, some expectation was there, either expressed or implied, and you simply misappropriated dishonestly with an intent of causing wrongful gain to yourself or wrongful loss to me, and you use that property against the directive of the owner. In that case, you have committed criminal breach of trust. That is something that has to be kept in mind. So I hope you got some idea about it, criminal breach of trust. Moving on. Cheating, another very important offense. Now, cheating and criminal breach of trust are often used interchangeably, but the offenses are a bit different. Very simple. Now, cheating simply means if I use deceit by dishonest or fraudulent inducement. Now, what is meant by deceit? Now, deceit simply means saying something without believing it to be true. Yani intentionally lying. If somebody lies intentionally, that is what we call deceit. The intention is, if what I say, I believe it to be true, then it cannot be considered as cheating. First element of cheating is deceit. What I am saying to you, I believe it to be a lie. That then only it can be considered as cheating. You'll have to prove कि सर ये जो इसने फैक्ट कहा है, ये खुद भी मानता था कि ये झूठ बोल रहा है. If you lie knowing it to be, if you make a false statement knowing it to be false, or you make a promise without having the intention of fulfilling it. Empty promise is also deceit. अगर आप किसी को वादा कर रहे हैं but you do not have the intent to go through it, it is called deceit. Deceit is dishonest or fraud. Deceit is simply either making a false statement knowing it to be false, or making a false or empty promise. Now the second element is of cheating is dishonest or fraudulent inducement. When you lie to someone, it need not be dishonest. You lie to people all the time if you want to play a prank, or you simply say your intent is not dishonest. If your intent is not to gain wrongfully or cause wrongful loss to another person, or not to wrongfully gain by it, then deceit is prank. That's how you can differentiate between prank and cheating, is whether your intent is to harm that person and gain yourself or not. Simply we all say lies to our friends, to our families all the time. अगर आपसे कोई पूछे कि भाई, if your mother asked me, दूध पी लिया, and you said yes, you obviously you committed deceit. But obviously there is no dishonest intent. We lie all the time, but lying does not become cheating unless it is with the intent of causing wrongful gain or wrongful loss. Then, if I make a deceitful statement, if I cheat that person in the sense that I make a false statement, knowing it to be false, and try other person and induce their person. Induce matlab, I am trying to make that person act on that deceit. मैंने आपको कुछ कहा और मैं चाहता हूं कि मेरे उस झूठ से प्रभावित होकर आप कुछ करें. That is called inducement. If I come to you covering my one hand and say कि देखिए मेरा एक हाथ नहीं है, या मेरी एक टांग नकली है, मैं बहुत हॉकी का बहुत बड़ा प्लेयर था. If I want that you should do something about it, give me money or help me, that constitutes inducement. If you have lied and you intend that based on your lie, other person should do something, and that inducement leads to delivery of property or any act or omission that the person would not have done if he would not have been so deceived. अगर आप किसी को with an intent of with dishonest intent you deceive someone, आप किसी को धोखा देते हो, you make a false statement knowing it to be false, you deceive that person fraudulently and then induce that person into either delivery of property or any act or omission that a person would not have done if he would not have been so deceived. Then what we call is cheating if such act leads to damage or harm in body, mind or property. Some kind of loss should also happen to constitute cheating. Now I'll give you examples. Or reputation, body, mind, property or reputation. Achha, mind is also there. So mental loss or mental pain is also considered to be in the domain of cheating. If by your cheating somebody else suffers some mental loss, in the sense mental pain, that will also constitute cheating. I'll give you an example, very simple example. Mobile frauds. So I say that I am calling from ICICI Bank, your KYC is pending. So kindly tell me the OTP. First, I have lied. What I have lied? That I am calling from ICICI Bank and the other that your KYC is pending or something. Then I have made an inducement. Inducement means I am asking the person to do something. Now, asking other person either to give property, like lottery mein hota hai. Let's see, you have won lottery, you transfer us 10,000 so that we can give you the lottery amount of 50 lakh, 1 crore, whatever the case may be. So if I have induced the person into delivery of property, that constitutes cheating, or any act or omission, like giving OTP, that the victim would not have done. अब इसके लिए बड़ा important है cheating के लिए कि by deceit I induced you to do something that you would not have done if you were not so deceived. It means that I have made a false statement and you believed in that false statement and did something which you would not have done if you knew the truth. जैसे कि अगर मुझको मैं कहूं कि सर मैं स्कैमर बोल रहा हूं, मुझको ओटीपी दे दीजिए और आप ओटीपी दे देते हैं, then it is not cheating. because that person never made a false statement. Cheating का पहला element है that you deceive someone, you commit deceit. Now, if the person was truthful and honest about it, absolutely no problem. That does not constitute cheating. The police will say कोई offense ही नहीं बनता. But other person says that I am calling from bank. If they would not have said that, then you would not have given them OTP. In that case, cheating is considered to have been committed. And obviously, there is damage to your property. So, cheating के लिए it is required, it is mandatory that there must be a false statement. Another example, let's take. Suppose I tell you that somebody taking the other person's bodily organ by cheating. I tell you, Kisi, I will cure you. You are facing some problem. If you have stomach pain because of a particular tear in intestine, I'll treat that. And you gave consent to that surgery. And I took the organ out. I took the kidney out. Whether you would have given that consent if you knew what I was saying is wrong? Answer is no. So in that case, it caused damage to my body. Anything that you would not have done if not so deceived. I once saw a person selling fake kaju. They made the kaju from, I think, maida or something, wheat flour, wheat. And they made it exactly in the shape of a cashew. And then they were trying to sell it to the people. See, for the kaju is 1,000 rupees kg, I am selling it for 200. So it's so cheap. But actually it was not cashew, it was cashew biscuit. It was biscuit in the shape of cashew. So they were this gave that cashew to people in train, and even before somebody could realize what has happened, they simply ran away. So that constitutes cheating. Because what they did, they made a false statement. On the basis of believing that false statement, the victim gave them property or did something that they would not have done if they were not so deceived. So that will be considered as cheating. Another interesting example about it, suppose Mr. A goes to Mr. B's house. Now, he sees that there is a very precious artifact, very old artifact in the house of Mr. B that is worth lakhs of rupees, and Mr. A is not aware about. Or he has an old painting which is very unique. So Mr. A says to Mr. B, see, you have in trouble in your family, you have fights with your wife. So all this is because this is some vastu dosh, some problem, and this artifact that you are having, it is upshagun, it is black magic, or it is somehow brings bad luck. So what you should do, you should just take this artifact and leave it below the peepal tree on Saturday night, and you should not look back. And that happened actually with one of the person known to me. So other person goes with that artifact, that painting, and simply puts it in below the peepal tree and walks back, because superstition, we are all superstitious. India is full of superstitious people. So other person, Mr. A, who made that false statement, goes and takes that painting and sells it for millions of dollars. Now what he has done, he has made a deceit. He makes a false statement, knowing it to be false, and his intent was obviously dishonest, and he made an inducement leading to, that inducement was made to the person that you should act, you should do something that you would not have done if he were not so deceived. So in that case, he took the painting out of his house and kept it below the peepal tree. That constitutes cheating. And obviously he suffered harm. It caused damage to the people who owned that painting. Even if they were not aware about its true value, still they suffered loss. And thus it constitutes cheating. So cheating can be done. Now, see, earlier the provision for cheating was 420. Section 420 gave punishment for cheating. and this was very popularized. 420. It was section 420 in IPC. Obviously, the new section is changed in BNS. Now it's no longer 420. So BNS actually took away that particular nickname for any person who is a cheat. Was called 420. 420 was about section which punished cheating in IPC. Now in BNS section is different. You can check. Okay. So cheating can also happen by personation. Suppose I impersonate someone. I go and tell someone, see, I am the district magistrate of Jabalpur, so give me this. Or you simply portray yourself as a police person, as a doctor. So people cheat by impersonating. We see all the time in the news that a person was a fake IS officer, IPS officer, army personnel. So you impersonate someone else. Now that constitutes cheating. That is what we call cheating by impersonation. You act in a way, you behave like someone, or you try to portray someone else while you are not that person. That constitutes cheating. So cheating basic idea I've given you. Let's move on. Forgery. This is something that you must have done. It simply means making a false document or electronic record. False document is anything. If you have made a document you had no authority to make, or you signed a document which you had no authority to sign, or you signed it in someone else's name, all these constitute making a false document. So if you make a false document to cause injury to public or to any person, means you have wanted to cause any harm, or you wanted to support any claim, or enter into contract or commit any kind of fraud, that constitutes forgery. So forgery has two legs. Number one, it is about making a false document. So every time you forged a signature of your parents on a report card, on a school diary, you have made a false document. Because you signed a document you had no authority to sign. If you make a document which you have no authority to make, that constitutes a forgery. Simply electronic record as well. Electronic record, if you mail someone on someone's behalf and you are not that person, if I write a mail and say I am, let's say, Vice Chancellor of Delhi University, that is what we call will be a forgery, because I have made a false document or electronic record. Electronic record, all these have been added by the IT, Information Technology Act. And because of that Information Technology Act, if anybody makes a false document or electronic record, and the intent behind that making of that false document or electronic record is to cause injury either to public. Suppose I make a false document like stamp. That comes within the domain of counterfeiting, but still, suppose I make a forged stamp, forged birth certificate, forged marriage certificate. Now, sometimes a forged caste certificate, let's say. Now, injury to public at large will happen because of that. Because somebody who is deserving will not get the seat. If I get a forged document for the purpose of getting scholarship or job, suppose I make a false certificate for being physically disabled. Recently, there was a allegation on an IS officer that she gave a forged certificate of disability in order to get job, getting selected in civil services. That will constitute forgery. That will constitute making a false document and causing injury to public at large. Now, public here means public at large, or it also means harming the government or any person. If you are trying to harm any person, you have made a fake will, you have made a fake property document, all this constitutes forgery. Or if you want to support any claim, like making a will support a claim. Suppose you are making some false evidences, false money trail, or in back date, fake invoices you are creating. All those things will be considered as forgery. or if you have made a false document in order to enter into a contract or commit fraud. In the sense, let's say I want to study law, but I have not passed 12th exam. So I make a false 12th certificate and I submit it to the university. Now that constitutes forgery, because you want to enter into an educational contract, or you are supporting your claim to that seat in BLLB. Even you cleared CLAT, even if you are CLAT AIR1, but if you suppose for getting that seat, you made a false 12th certificate. Now that constitutes forgery. So forgery simply means when you are making a false document. False document very simply means that you have made a document you had no authority to make, or you have signed a document which you have no authority to sign, or you have signed in someone else's name. You put a mark or signature on a document which was not within your right to place. अगर आपने कहीं पे मोहर लगाई जो लगाने का राइट आपको नहीं था, फर्जी मोहर बनाई. People do that all the time. If you can find the right lawyer for it, they have all kinds of muhar stamps. So making false stamp is also a type of forgery. Now you cannot place your signature stamp on any document that you are not authorized to sign. Okay, that constitutes a false document. And if you have made a false document in order to commit prank, it's fine. If your intention is not to cause injury to any person, you are suppose simply want to create a, suppose I made a forged love letter just in order to play a prank on my friend. Sometimes people write fake messages to their friends from fake ID. Now obviously that is also fake electronic record. If I make a ID on behalf of a particular girl and I make a false, I just upload a fake picture and I text my friend, hi, what you are doing, I like you and all. You must have done that, or either you are perpetrator or victim or any of such crime. So if you have done that, that also constitutes a false electronic record. But your intent is not to cause injury to any public or to any person, or neither you are supporting any claim. But if you are actually write that, okay, I don't have recharge for me 5,000 rupees, send me 5,000 rupees, that constitutes forgery. That will become forgery. So all these people who are have a lot of fake IDs and they are using or exploiting those hopeless romantics, they are doing forgery, because you are making a false electronic record. Even if you are writing a message on behalf of someone, suppose I am Angel Priya is a very famous colloquial term. I sign, if I am Animesh Jha and I text someone portraying myself, that is cheating also, but that is forgery also, because I'm making an electronic record. So the moment you are making a document or electronic record, you make prem patras on behalf of someone. There's a story in of Premchand called Vinod. You can read that. That is about forgery, not about forgery, but the instances that I talked about. In that, forgery is also involved. It's a Hindi story. You can find, if you can read Hindi, you can read that, or you can get it to translated in AI, so you can read it. It's a very beautiful story called Vinod. Okay, moving on. Today we are also talking about some other offenses against property. I'll give you a brief idea about these offenses. First is mischief. Mischief simply means destruction of property. If by your act you are depreciating, devaluating, destroying a property, you are doing an act by which the value of the property, the utility of the property is reduced, or the property is destroyed, then you have committed mischief. I burn someone else's house, kill someone's pet, harms, throw ink on someone's shirt, everything is mischief. If you reduce the value, utility of any property, or you have destroyed any property, you have caused mischief. Now, mischief can be in respect of animals, it can be in respect of any property. तो किसी की फसल जला दी मैंने, किसी का घर जला दिया, गाड़ी तोड़ फोड़ कर दी, all falls under the domain of mischief. If I do harm someone's vehicle, house, any property for that matter, it's all your imagination. If I threw a shisha tod diya maine kisi ka, that is also, if you broke a glass, that also constitutes mischief. So the domain of mischief is very wide. How you are committing mischief, the punishment depends on that. So normally there's very little punishment for mischief because it's essentially you can sue there's a person for damages in civil law, but at the same time it's criminal offense. When the magnitude is higher, sometimes criminal offense is also registered and punishment can also happen. Actually, if you are doing mischief by fire, that's a higher offense, that's a more grave offense. You should not use fire to destroy anything. Okay, now criminal trespass. Trespass is simply entering into someone else's property. Now, that trespass becomes criminal if your intent is to commit an offense or cause annoyance to the person. If you are entering someone's property, then it itself might be trespass, might be a civil wrong. It becomes criminal when your intent is to commit an offense or cause inconvenience or annoyance to the other party. So that constitutes criminal trespass. Now, criminal trespass ka bada bhai hai, it's a higher offense, is house trespass. If you enter someone's house, and if you enter someone's house by concealing yourself, that is what we call lurking house trespass. So all these, there are offenses which have some aggravated forms. So criminal trespass is there, house trespass is there, lurking house trespass is there, lurking house trespass by night is there. So higher offenses. Then we have house breaking. House breaking means if you enter into someone's house by breaking it, by somehow destroying the barriers that are placed in that house, that constitutes house breaking. House breaking is घर में सेंध लगाना. सेंध लगाना means you have not entered by the main gate or by which you are supposed to enter. You have entered by some other route, or you have forced yourself into someone's house. That is considered as house breaking. And house breaking not only is about residential house or any place where the property is stored, like shop. अगर आप किसी की दुकान में भी घुसते हैं, that constitutes house breaking. Trespass, simply if you have entered, even the door is open, you have entered, that is constitutes trespass. But house breaking is when, if you enter someone's house when the door is open, that is not house breaking. House breaking means you have entered that house by force, by destroying or by removing the barriers that are there in the. That will constitute house breaking. That's also a separate offense. Then we have stolen property. If you buy or sell, or you keep in your possession some stolen property, in which you either know or you have reasons to believe. So this is very important to understand. If you have reasons to believe that this property is stolen property, like somebody gives you a fully functional iPhone for rupees 10,000, iPhone 16, let's say. Now, what will you deduce from that particular fact? Very simple, that phone is stolen. How it is possible that somebody is selling a new iPhone 16 for rupees 10,000? No, impossible. So sometimes either you know that this property is stolen, or you have reasons to believe. If the person who is giving it to you does not seem to be like the owner, or he cannot actually tell you from where he got that particular property, or that property is being sold in haste or in extremely disproportionate price, in that case, it will be considered that there are reasons to believe that this is stolen property. Thieves, when they are selling the property, they are very cautious. They just want to sell it immediately in whatever price they want to sell. They are ready because obviously they have not invested anything. So that happens all the time. So stolen property, if you deal in a stolen property, if you have purchased that, knowing it to be stolen or having reasons to believe that the property is stolen. If you think or if the circumstances are such that it compels this particular analogy that the property is stolen, in that case, you are not supposed to touch that property. If you touch that property that constitutes stolen property, then it will be a punishable offense. So I hope that much is clear. Okay. Then the last and very interesting, this is added in BNS. It was not there in IPC. Snatching is added. Section 304 of BNS talked about snatching. Now, snatching simply means if somebody forcibly and suddenly takes some property from someone. Now, see, either the theft can happen either by the people who commit theft. Either they try to disguise themselves, they're very slow, or they're very fast. In the sense, they will immediately, forcibly, and suddenly, if you take someone's property and run, that constitutes snatching. We all understand what snatching is. Chain snatching, mobile snatching is very common. It happens all the time. Somebody or the other person, you might have heard that, or it might have happened to you as well. Somebody has attempted. Once that happened to me, somebody tried to snatch my phone, but my phone was apparently very slippery and they could not get hold of it. Snatching, people do it all the time. Especially women, you must have heard that golden chain people try to snatch. So snatching is a grave offense that has been incorporated. It was not there in IPC, it was incorporated. How it's different from other crimes? When suddenly somebody tries to forcibly seize a property and then tries to run away, that constitutes snatching, and that is a separate crime for which there is a punishment for 3 years. So there are other offenses against property. There are some more offenses like counterfeiting currency or making stamps and currency notes. All those things are there, but not much relevant. One more important aspect is there, defamation, that we will discuss in the next lecture. So I hope you got some idea. Next lecture, we will discuss offenses against marriage and reputation, and we'll conclude this module, substantive criminal law, and move on to procedural law. Thank you so much for being patient listeners. I'll see you all in the next class.